Hello, everybody. First thing I want to say is, unfortunately, the guest speaker had to cancel today, but I've got a really good presentation. A few weeks ago, or actually a few months ago, we did a presentation on what to do in anticipation of a visit from a social worker. Well, today's presentation is going to be items that are helpful in a claimant position statement. The reason why I'm putting this together, in the last week, I represented a client in a matter that I was asked to represent after they had already made several postponements, so I didn't have the opportunity to package together the position statement beforehand. And I thought the case was a very good case, considering the fact that there was a one-on-one aide that was involved at school. But when I went to hearing and the evidence was presented, I realized that I was missing several documents. And as a result of missing those documents, the case wasn't as strong as it could have been. And so what I have done today is I've kind of reflected back on those items that were missing from the matter in which I'm referring to, and putting together what I would consider to be a list of best practices for documents to include in a position statement that you would submit for an administrative hearing. I want to give credit to David Wolf, my business partner, as he is the one within IHSS Advocates who actually is responsible for compiling together these position statements. And so these are actually his suggestions of documents that he thinks are essential for a position statement for administrative hearings. There are 14 items on this list. I think they're all very, very relevant. And what we'll do is we'll go down these items one by one, and I'll provide some insight into each one as to why I believe they're important for an administrative hearing. The first one, which I think everyone will agree is extremely important, is going to be the IEP, the Individual Educational Plan. And the reason why this document is important is because it has not only parental reporting, but also has observations from those individuals who work with the potential recipient on a daily basis, 5 days a week, as well as behavioral goals that have been established by a IEP team. And so because of the fact that all these things are typically present in an IEP, it's a really good document to use for an administrative hearing. In fact, there are some e-notes that have been written in the last couple of years that actually give administrative law judges the ability to use information that's contained in an IEP and make assumptions that if it happens at school, it must happen in the home. And so for that reason, an IEP is an essential document when going to administrative hearings. Another document would be from Regional Center, and that would be the Individualized Performance Plan, and that would be the IPP. Now that one tends to be more of a parent-driven document. That's not a document that's drafted by a team. That's a document that's typically information is provided by a parent, and then it's captured by a employee from the regional center. But that's a very, very relevant document because that is an expression of parent reporting. And that's probably going to be, in my opinion, your most genuine observations from the parent's perspective, because it's given at a time that's not necessarily in connection with trying to obtain a service like protective supervision, or trying to get a service like an accommodation at school. It's usually, even though it's parent reporting, it's usually done at times that are independent of other events, and therefore it's more of a free expression of the parent in expressing the needs and concerns of the recipient. Once again, it is parent reported material. It will also potentially contain observations. If for some reason the regional center worker sees something in the home during that 1 hour period of time that they're conducting the IPP, that will typically end up being in the document, as well as behavioral goals. And sometimes the behavioral goals will find themselves into the CEDAR, which is typically used by regional center in determining whether services should be rendered or not. Another document that I think is very, very relevant, although not everyone has this, is going to be ABA notes. And most of our kiddos do have some form of whether it's the applied behavioral analysis, or whether it's some type of behavioral intervention, that type of thing, whether it's at school, whether it's provided by regional center, whether it's funded through Medi-Cal, wherever these services are offered. The observations that are in the notes are very relevant, because once again, this is an individual who is a third-party individual who has the task of providing some type of a treatment plan for the recipient, and therefore you're going to have things like behavioral goals, but you're also going to have observations and data collection. And the data collection is extremely important, because the data collection that is done for this document, or these documents, is data collection that is used to gauge whether or not the actual treatment itself is beneficial or not. So what you're going to see with ABA reports is you're going to see either your child is progressing, your child is staying the same, your child is regressing, and they're going to have baselines, and you're going to have really good data collection on behavior, not just the educational goals or the educational progress that you would see in an IEP. So ABA actually tends to be more geared towards the types of observations you'd want to have for an administrative hearing, given the fact that protective supervision does tend to be geared towards the concept of potential danger, or the inability to assess potential danger. Another report that's very relevant is a psychological assessment. And these are typically associated either with transitional periods, like, say, for example, regional center going from early start into what I call typical regional center at age 3. Also, you would normally see a psych assessment when transitioning at age 3 with the school district. But then again, you would also commonly see a psychological assessment when you have triennial reports every 3 years with the school district. And these reports are very relevant, because they typically will include observations in the classroom, or observations that are done by a trained clinician in regards to the psych assessments that are done by, say, a regional center. So you're going to have observations, you're going to have baselines, and you're going to have conclusions based upon those observations and baselines. And it'll give a determination as to whether the recipient has a mental impairment, and it'll also, in some cases, even indicate what the level of severity is. So this is actually a very good document. When appropriate, SCIA assessments. Those are going to be for those kiddos that have special circumstances, individual assistance. And that's going to be the one-on-one aides. That's going to be whether the one-on-one aides are ABA trained or not. That's going to be information that's going to be provided based upon observations in the school to determine whether or not the SCIA is or is not still required in the school setting. Also, for those individuals who are older and they have conservatorships, the capacity declaration that was submitted with the conservatorship is also very relevant. Once again, it's a document completed by a licensed clinician, and it's been completed for a function other than the assertion of protective supervision, and therefore it's given, in my opinion, higher weight than, say, an SOC 821. And of course, the SOC 821 form, which we've just referenced, and that's going to be based upon parent reporting, possibly some observations by a doctor. They may have seen, during those times in which the recipient has actually been in the doctor's office. But the important thing about an SOC 821 is that the clinician that completes the report is acknowledging that the individual has a certain level of need, and possibly indicating certain types of behaviors that they've either witnessed or have been reported by the parents, and also will indicate the duration of time that the recipient has had the disability, and what the prognosis is. And so the SOC 821, even though there are many social workers and judges who might tell you that it's by itself doesn't stand alone as a convincing document, it would support your third party documentation. It's still a document that's completed by the parent, and it's still a document that is validated by the doctor. And so, regardless of whether you want to say it's parent reporting, and somehow the parent has gotten in the ear of the doctor, and that the scores on the document may be impacted to some extent by the influence of the parents, the doctor still has to sign it. The doctor still has to say, yes, I'm going to risk my reputation and risk my standing as a licensed clinician in the state of California, and agree that I believe that this parent's reporting is accurate. And so, you're not going to find many doctors who are going to, fabricate information simply because of the fact that they don't want to, suffer any consequences as a result of doing so. They have no skin in the game. That's the term that I use. They have no skin in the game. And so, because they have no skin in the game, they're a third-party, individual. It would be silly to assume that they're going to somehow collude with the parent and create a document that is absolutely fabricated. Another document that's useful is the Occupational Therapy Report. I have that on my list here, along with speech reports and physical therapy reports. These are obviously types of treatment therapy that could have good information in regards to observations seen during the therapy sessions. It also shows, at least in terms of the physical therapy, actually I would say probably all three of these, it would show to what degree the recipient has an ability to ambulate, to be able to potentially get into trouble. That's one of the steps for protective supervision. And so if you've got, reports of, climbing on furniture during the physical therapy session, or you've got, a speech clinician who's indicating that, every 15 minutes the recipient runs away from the table and tries to get out the door, obviously that would be information that would be very useful for an administrative law judge to review for an administrative hearing. A potentially dangerous behavior log is also very useful. So here's my thoughts on this. So I believe that a dangerous behavior log should be completed at the end of each day. I don't believe it should be a document that's completed throughout the day. I think most of the parents of kids with disabilities would agree that their time is better spent actually taking care of the child during the child's waking hours. This document should be completed, fresh on recollection of the day's events at the end of the day. And it typically is not going to contain everything that happens during the day, but it's going to give a sample of the types of things that happen during the day. And it's really important that if in fact it is a sample, that information is conveyed to the judge when the hearing happens, that even though it has 3 items on a given day, that it's not meant to represent that only 3 items happened on that given day. These are just the 3 items that were listed on the document at the end of the night based on recollection. And that's really important to specify, to an administrative law judge during the hearing, so they don't rely on that document as being everything that happened during the day. Because typically, those documents are drafted, like I mentioned, they're drafted at the end of the night, when the parent has a free moment and is able to actually sit down and actually complete the form. And it doesn't always encompass everything that happened during the day. Another document, or documents that would be helpful, would be incident reports, whether they're from school or from other agencies. When I mention other agencies, police reports is what I'm referring to. Obviously, those are going to be documents that are based upon individual occurrences. But clearly, if you have a situation where you have real injury or a real event that could have resulted in actual injury, that would be an example of a time in which the individual was able to actually either complete the function of hurting themselves or get very close. And so that would be something that would represent a need for those times in which redirection keeps the recipient away from actual injury. And the idea here is that you're demonstrating with this one incident what could possibly happen if you weren't redirecting, say, the other 25, 30 times that you're alleging. We also would recommend having relevant legal citations. The types of items that we put in our position statements as IHSS advocates are things like e-notes, all county information notices, all county letters, regulations, statutes, and relevant case law. And you could probably find a lot of that stuff either through Disability Rights. I know they've got information on this. We've got similar stuff. I've done enough of these presentations, and I've provided videos, and there's enough information within the IHSS advocates online community, I think, to establish these types of citations. Some of the ones that come to mind, obviously, that we refer to quite often are going to be things like All County Letter 1525, which indicates the 4-step process for determining protective supervision for a minor. There's also Garrett versus Anderson, which is All County Letter 98-87. Things like Calderon v. Anderson, which I refer to, Marshall versus McMahon, which I refer to, which are superior court cases. And then there's different types of MPPs, manuals of policies and procedures, and statutes. These are the things that would provide the legal basis for an argument that you may have, for an administrative hearing. And what you'll find when you go through the county's position statement is they've done the exact same thing. I don't think I've ever seen a county's position statement where they haven't at least listed some legal citations for their determination. And the last thing that's I think helpful in a position statement is whether it's a brief statement or whether it's more detailed, it's a rebuttal to the county's position statement. I'm sure there's probably things in the county's position statement when you receive it. It's supposed to be 48 hours before the hearing. When you receive that position statement, I'm sure there's going to be items in there that you're going to contest. And sometimes it's helpful to put that into written form. Sometimes when parents represent their kiddos in administrative hearings, they get kind of nervous, and sometimes they forget to say certain things, and they have regrets about not presenting certain items after the fact. Well, if you put together a statement and you stick it in your position statement, you don't have to worry about that because it's in a written form. You've written it before the hearing happened, and it's going to be part of the record. So, a statement, a rebuttal to the county's statement of position is also a very good document to have. So, any questions on anything? Well, thank you very much, everybody. Have a good day.